Case number 20-3061, United States of America versus Melvin Lawrence, appellants. Mr. Welch for the appellant, Mr. Goodhand for the appellate.
Good morning. Counsel
Morning.
for appellant, you may proceed.
Good morning. May it please the court. My name is William Welch, and today I would like to speak with you about allocution. Congress has authorized a resentencing remedy to correct the racially disparate sentencing scheme that's based on crack compared to powder cocaine offenses. And last year, this court said that when considering motions for such relief, giving full and fair hearings is important to ensure that the goals of the statute are met and that a range of sentencing factors is relevant. And that was in White versus United States, 980, Federal 3rd, 76, Pin Site 81. In addition, Federal Rule of Criminal Procedure 32 says, before imposing sentence, the court must address the defendant personally in order to permit the defendant to speak or present any information to mitigate the sentence. Historically, people believe that defendants have the opportunity to allocute at sentencing. Although it's not a fundamental right, the right of allocution is grounded in the common law.
What about Dillon?
I'm sorry, did someone have a question?
What about the Supreme Court's decision in Dillon?
Dillon was not a First Step Act case, Judge Wilkins. I understand why that's relevant because, of course, the district court relied on Dillon in this case, but it also relied on the district court's opinion in White, which came out before the DC Circuit's opinion in White.
What about Rule 43B4?
I'm sorry, I didn't hear that, Judge Millett.
What about Rule 40, Federal Rule of Criminal Procedure 43B4, which says that presence is not required for the correction or reduction of sentences under, including 18 USC 3582C?
Well, except this is not squarely a 3582C case.
What do you mean by not squarely a 3582C case? Is 3582C the source of the exception to finality in this case?
I would not go that far. I don't want to ignore a federal rule of criminal procedure. I realize that the court needs to consider the whole scheme of things, but this seems different because the First Step Act is a remedial statute.
No, I just want to stop. I just would like an answer to the question of whether this is a reduction of sentence under 18 USC 3582C, and that's the basis on which 404 is brought in.
I don't believe it is. I don't believe that Congress relied on that.
I just want to know, so you don't think you're not proceeding at all under 18 USC 3582C?
I would not say so, Your Honor.
You would not say so, so that's a long way of saying no.
Right.
You have nothing to do with 3582C.
It's not, this argument doesn't, I certainly understand why, because that involves sentencing reductions, and certainly Congress is telling the district court to consider a reduction because of crack versus powder cocaine disparity. But ordinarily, it would seem that 3582C would have to do with changes in the guidelines, perhaps more of a clerical type mistake, whereas this is basically saying to the district court, go back and consider whether this sentence was greater than necessary under the circumstance. Go back and reconsider the entire sentence, consider the 3553A factors, and ask the district court, do you still come out to the same sentence? Because of course it isn't a mandated reduction either. I mean, in this case, it ended up seeming like that because the actual statutory maximum changed. So they had to, the district court had to reduce the sentence, but ultimately ended up imposing the maximum, which it hadn't previously. I would like to reserve the balance of my time in rebuttal, but if the court, I hope I answered your question, Judge Millett. And if the court has any other questions for me, I'd like to reserve the balance of my time.
Do you seek a sentence modification
It
or sentence reduction?
is a modification of the sentence. There was a de facto reduction in the sentence, an absolute reduction in time.
I'm asking what was sought in this case. It was a reduction of sentence.
Well, yes, that is what Mr. Lawrence.
It wasn't an entirely new sentencing where he would be subject to increases or decreases or anything like that. It
Could not be subject to an increase at this
Right.
sentence.
It was only a reduction, but you don't think that's a reduction of sentence within the meaning of Rule 43B4?
I understand why it might be, why it might seem.
No, I'm really just asking your legal theory here.
That's all, yes.
The legal theory here, from Mr. Lawrence's point of view, is that we should have had, this was a resentencing. This is almost like the sentencing was vacated and you send it back for a new sentencing. We think that would be a more appropriate approach to this than simply saying, okay, there was some clerical error, there was a guideline change, you got to go back and just recalculate some aspect of the sentence. This is Congress saying, take a fresh look at the whole sentence and redo it.
Just one other question, sorry. You argue for allocution on this case, but I didn't ever see you say what it is that Mr. Lawrence would have said at allocution that wasn't either said in your brief or already said it as prior allocution.
Well, he never had the opportunity, and that's the problem. There's no transcript.
Normally one has to show prejudice, and so that's what I was confused about. What have you done to show what he would, if he had given allocution, that he was prejudiced by the absence of allocution?
Well, he's prejudiced because basically the government has been able to point to his history in the BOP since the earlier sentencing, and he's been denied the opportunity to respond to that and to explain.
Why couldn't you have explained it in your brief? Why wouldn't, I mean, the government didn't allocute when it made those arguments, it did it in a brief. So I'm just wondering where if he had an answer or a response to that, why wasn't it in the brief? Well,
that's a fair question. I would just say that the best person to speak to his progress and what he's dealt with in the Bureau of Prisons is Mr. Lawrence himself in allocution.
Have you talked to him about it? I don't mean to intrude on privilege here, but I'm just
sure
as to how can I have comfort in knowing that there's something to be said since there was nothing included in the brief?
Well, fair point. I will just say that my client is one of the more challenging folks I've ever had to speak with, and kind of trying to virtually get him focused is a real challenge because I haven't been able to go see him either and have a real conversation and explain to him, listen, this is what allocution is about. This is what you need to be prepared to do. What would you say? Doing so on a telephone is not the same. So I realize that isn't a direct answer to your question, but that is the history of this appeal.
Okay. Thank you.
All right, let us hear for counsel for the government.
Thank you, Your Honors. May it please the court, David Goodhand for the United States. Eighth Circuit Court of Appeals have concluded that a hearing with the defendant's presence is not necessary in this context. That is an understandable conclusion given the statutory text of the First Step Act, which establishes that Congress also authorized only a limited adjustment to an otherwise final sentence. If you first look at the statutory text, establishes it's simply a motion to reduce, impose a reduced sentence, not impose a sentence or impose resentencing. Second, of course, as the courts have made clear, there is the as-if clause, which permits a district court to alter a single variable, go back in time and establish the effects of the amendments to sections 2 and 3 of the Fair Sentencing Act. And the district court probably did that here, went back, considered the changed career offender guideline, which was hinged on the statutory maximum and minimum, and altered the base offense level accordingly. The district court also, I would suggest, very presciently anticipated this court's decision in White, considered the defendant's post-sentencing conduct, also considered the 3553 factors, and carefully adjudged, finally, I would suggest, the defendant's arguments. He made several arguments in mitigation relating to his age and purported minimal risk of recidivism. He also made an argument relating to his medical condition, and finally suggested that his criminal history suggested that he was appropriately considered for a reduction. The district court carefully considered all those factors and concluded that a reduction of 10 months to the statutory maximum was appropriate, but no more. So
Can I ask,
Could I just ask you quickly, although it's not argued here by counsel in his brief, both in the opening brief and reply brief, he suggests that under this statute, the district court was required to say something about the sentencing disparity, and that here the district court made no reference to that. What is your response?
I read Wright to stand for the proposition that a sentence pursuant to the First Step Act, a reduction, should be procedurally reasonable. Procedural reasonableness in this context does not require a sort of ticking off of all the 3553 factors, that is, every one of them in course, including disparity, of course, being a 3553 factor. So in this respect, the district court, in her opinion, made it clear that she had considered the 3553 factors. That's an appropriate, procedurally reasonable articulation of an adequate sentencing rationale, I would suggest. And number one—
About the response in part, that I just want to be clear about this. You do think that, or are you in agreement with the argument being made by Appellant that there was a requirement, given this statute, to look at disparity, or is the statute itself the only consideration of disparity that was necessary? In other words, Congress has already considered the disparity and allowed this mechanism to address it, and there was no further requirement. Appellant seems to be arguing that there is.
I think disparity comes in play here in two places. One, Congress has already considered it in making the Fair Sentencing Act amendments retroactive. So that disparity is already considered by Congress in giving district courts the discretionary authority to reduce. But also, as I understand it, White from this court has suggested that 3553 factors should be considered by district court. And I think, of course, 3553 has a reference to disparity. So I think it's considered in both places. Here, we know that the court considered the overarching goal of Congress, as the defendant concedes even in his reply brief. The district court made mention of the core purpose of the First Step Act, which was to account for disparity. So I don't think there's any doubt that both via her consideration of the 3553 factors and her understanding of Congress's goal with respect to the First Step Act, this court considered disparity.
Can I ask a question that's puzzled me? So when Mr. Lawrence was sentenced to 250 months, that was a below guideline sentence. That because the guidelines range was 262 to 327 months. And after his guidelines were recalculated by the district court here, the district court found that the guidelines range pursuant to the First Step Act was 210 to 267 months. Mr. Lawrence had served 209 months just under the guidelines, and he asked for time served. So instead of, the government opposes that, so instead of him getting another sentence that's below guidelines, he gets a sentence that's basically at the high end of the guidelines, or I guess you could say, more fair to say, middle of the guidelines, because the guidelines range for now is 210 to 267, but the statutory maximum was 20 years or the 240 months. So how does this seem? How do we square the fact that he got a below guideline sentence before, and he goes in for a reduction and he gets a within guidelines sentence, and how is that compatible with how this is supposed to work? I mean, the whole purpose of this is to deal with this crack powder disparity, but one way of looking at it is that he got no benefit at all. He went from getting a below guideline sentence before to getting a within guideline sentence.
Is true at the 2009 resentencing, the district court varied downward from the guidelines, and in fact, in part, the district court varied downward in consideration of the defendant's counsel's argument about the disparity, though recognizing that the current statute that was being contemplated at that time didn't necessarily alter his career offender guidelines. The district court in 2009 nonetheless did come down in a variance from the guidelines recommendation. But the district court in 2009 also considered the defendant's criminal history, his lack of remorse, and the seriousness of the offense to conclude that that variance was an appropriate sentence. I would suggest the district court here in 2020 looked at that number and concluded that it was appropriate still, to the extent that the statutory max, the career offender baseline was accounted for via the amendment, but the court looked again at the court. For the record, I would note that the Judge Kolar-Catelli pulled the resentencing transcript, looked at that resentencing transcript, looked at the PSR again, but ultimately concluded, in light of the defendant's disciplinary record in prison, the post-sentencing conduct that White says is appropriate for this court to consider, district court to consider. The court concluded that the number 240 was an appropriate number, and in particular, she highlighted the danger to the community that she thought the defendant represented. So I don't think there's necessarily a requirement of exact proportionality, and I think Chavez-Meza speaks to that in the 3582 context, C2 context. They actually declared proportionality is not necessarily required. Instead, it's again a question of substantive reasonableness of the sentence that results. And here,
is there a requirement to say, well, there was a variance downward before, but I'm not going to vary downward this time? And did the district court acknowledge that it was essentially, kind of changing the construct from the first sentencing?
I'm sorry to interrupt. I don't think there has to be an express articulation. Again, we have to look at the totality. Rita says every case is different. Every sort of sentencing explanation will be different. I don't think there's any doubt the thoroughness of this district court opinion demonstrates she full well understood what the district court did in 2009. The fact that she didn't say, well, I recognize there was a variance then and I'm not doing that variance here. Given the reasoning, I think that supports the conclusion that she understood that a variance here was not appropriate.
White says no less than 3 times that a hearing, it first says it is important that they, meaning defendants being resentenced under the First Step Act, be given full and fair hearings on their claims to ensure that the goals of the act are met. And then it says again later in the opinion, it notes that nor did the court hold a hearing on appellant's motions for relief. That's again at pin site 92. And then for full measure, a third time at, let's see, I guess it's also at pin site 92. It says, and the court did not hold a hearing on appellant's motion for relief. So how are we to interpret what the court meant when it said, and it is therefore important that they be given full and fair hearings on their claims?
I think White tells us what that means. There were 2 flaws identified in the White decision relating to the district court's analysis of the sentencing. First, the district court did not indicate that it had considered the voluminous mitigating evidence provided by the defendant in support of his First Step Act motion, number 1. And number 2, White identified a second failing omission on the district court's part in the White First Step Act context. That was, it wasn't apparent that the court had considered all the relevant factors that should apply to a court's discretionary decision in the context of a First Step Act motion. And what critically, I think what White did is indicate that if the court had had a hearing, we might have had an indication on appeal for the court to review whether or not the district court had indeed considered those. But the court additionally noted there also wasn't any reference in the opinion to either the mitigating evidence or the consideration of the relevant factors, the 3553 factors.
Well, why didn't the court just say it's not in the opinion, so we don't know whether the court considered it? The district court considered it. I mean, you don't have to then go on for 3 separate occasions and say there was no hearing.
Well, I think a fair reading of White is that a district court could have adequately accounted for this, as this district court did, by writing an opinion indicating the court had considered the mitigating evidence, indicating that the court had considered the 3553 factors. But I read White to stand for the proposition that we had a blank void in the record. There was no hearing, no transcript to consult, nor was there an opinion that made reference to these critical features of the First Step Act discretionary sentencing. So, and again, particularly I look at page 92 of the White opinion. The district court's opinion fails to mention any of this evidence, nor did the court hold a hearing on appellant's motions for relief. I read that, the government reads that as suggesting that was, you could have covered your bases either way, but we don't have that here. We must remand.
What's wrong with the reading of White to say, following White in this case, if you are going to change from varying downward to a within guideline sentence, and on top of that, base it upon the defendant's conduct in prison, then you ought to have a hearing so that you can give the defendant an opportunity to explain his post-sentencing conduct.
That certainly would have been permissible for the court to do that, but there's nothing that requires it, number one. And number two, all of that could have been hashed out via the papers. The government, in its response to the First Step Back motion, did detail in some fashion the disciplinary record it was going to ask the court to consider. It would have been a very easy matter for the defendant to reply to that. He did not. The court relied on it quite properly. And I think given White's instruction that sentences in the First Step Back context must still be procedurally reasonable, I think we have here a procedurally reasonable decision with an adequate explanation.
So I guess the question would be, under a plain error standard of review, that Congress passes a statute recognizing a disparity that it thinks was inappropriate, and therefore authorizes the district court to look at this sentence again in light of the First Step Act. And as your argument is presented, as I understand it, it's okay for the district court to treat this as a resentencing, as distinct from a correction. But it is not all right for the defendant to treat it as a resentencing in which the usual procedural requirements apply. That's what I just want to be clear about. So do defendants who file these motions know that they can end up worse off?
I think certainly they must understand, given, for example, this court's decision in White, post-sentencing conduct can be considered. And of course, we have to step back and look at this at the higher level here, which is this is all discretionary. The First Step Act doesn't require a district court to do anything. Once you account for the amendments to sections 2 and 3.
No, I think you're clear about that. But once the district court decides to do something, the question is, what is the First Step Act authorizing? This is not as though the government had filed a motion saying, look at his post-incarceration conduct. Let's reconsider the sentence. That's all I'm trying to understand.
Sure. I think all of this comes into play based on a mandatory consideration of the 3553 factors. So once you do the front end analysis, you account for the section 2 and 3 amendments, and you come up with any changes to the guidelines, you consider the new statutory mandatory minimums and maximums, then we are now into, I would suggest, 3553 factors, and that's a discretionary feature that is certainly familiar to defendants in this context. They went through it when they got initially sentenced. So that's that.
Understand what I'm getting at, don't you? The defendant thinks he's going in for a reduction. The district court is not obligated to give it to him, but does he also know that the district court can impose a greater sentence than his original sentence as imposed by Judge Penn? I thought that was the thrust of Judge Wilkins' question.
He did get a reduction here. He got the 10-month reduction. I think I understood Judge Wilkins to be asking whether or not the district court had to expressly articulate the reasoning why a downward variance from the guidelines was not again appropriate. And I don't think procedural reasonableness requires that when we have the thoroughness of the district court opinion here. But he certainly did get a reduction. And I think the question is, when you're assessing the scope of that reduction, does a defendant understand that the consideration of the 3553 factors might include post-sentencing conduct? Absolutely.
All right,
Anything further?
if
Good.
you are done, I just wanted to follow up on Judge Wilkins' line of questioning. It's not only was his position vis-a-vis the guidelines changed, but before he had been below the statutory maximum, now he is at the statutory maximum. And White said that district courts here have to give a sufficiently compelling justification for the sentence they impose. How can an explanation be sufficiently compelling under White's terms if it doesn't even acknowledge the change in position that's being affected vis-a-vis the statutory maximum and the guidelines range? Didn't the district court have to at least acknowledge that before he was below statutory max, now he's at it, before he was below guidelines, now he's in the middle of it? Here's why.
Well, I think the court did acknowledge that, to the extent that the court carefully went through what happened in 2009, acknowledged this.
Can you point me to where the district court acknowledged that while you were below, previously you were below, now you're going to the middle. Previously you were below the max, statutory maximum, now you're at it. And here's why.
It was, no, I do not mean to suggest it was that expressed. Absolutely not. The court did not do that.
Where are you implying it? What language implies it? Acknowledgement of those two changes.
In the procedural history, the court recognizes recognizes that, let's see, we're at page, the appendix 102, 103 is the court reviewing the 2009 resentencing and acknowledging that the court gave the variance. That's at page 103. The court imposed a sentence of 250 months incarceration. And then we have the.
Go ahead, keep going. I'm sorry, I apologize. Go ahead.
And then we have the court recognizing that the statutory maximum is now 20 years, 240 months. So we have the court
recognizing that his prior sentence was below the statutory maximum.
Well, I think that's in the, if it's not expressed, it's certainly incorporated into the probation office's it's ECF 132, which goes through this in detail.
No, but what White requires is sufficiently compelling justification by the district court. And
sure.
I'm not sure the probation office's report or an acknowledgement of a past fact in the procedural section of the opinion without explanation later for the specific determinations counts as a sufficient compelling justification.
Well, again, I think the sufficiently compelling justification does not have to be expressly articulated to the extent that the court.
I'm asking, like, sort of, in administrative law, if an agency is changing what it did in the past, we require them to acknowledge that they're doing that and then they explain it. And that's just for reasonableness review, not sufficiently compelling explanation requirement. And so I'm just trying to understand how we couldn't require that a district court, in its analysis of relevant factors, acknowledge that where you are with respect to the guidelines and where you are with respect to the statutory maximum, you're coming out worse. Yes, you've got 10 months less on your sentence. The law required that. That wasn't a discretionary judgment. That was absolutely legally obligated because the statutory maximum would change. So where is that? Why isn't that something that we should require of district courts in their making their discretionary judgment?
I don't think that follows from Rita and or Chavez Meza. Rita
what
said,
about White? I'm quoting White here on sufficiently compelling justification.
Sure, and I think White, the sufficiently compelling justification here is the lengthy disciplinary record coupled with the criminal history of the defendant, coupled with his risk of recidivism that was identified by both the BOP and the government. That is a sufficiently compelling justification.
And I have no idea. At his initial sentencing, when the probation office does the PSR. Is there a risk of recidivism noted there or not?
I don't know the answer. I guess I doubt it.
Okay,
but
that's not part of
again,
the sentencing fact, or it's not something that's thought about in the initial sentencing as part of protecting the public. And
right. Yeah.
So all we have is what the district court said at JA 103, where she says that the district court, Judge Penn, had afforded defendant, quote, somewhat of a variance, although not as substantial as counsel had requested. And then we get to 113 and 114, where she's reviewing his post-incarceration conduct.
Yes, and in the context of the thorough review she's done, of course, of the probation office's addendum, which identified the statutory maxes and the new base offense level. I would finish by suggesting this is not something I understand the defendant has even raised. I may be.
Well, note I started my question with plain error.
And I think that's an appropriate consideration here. I certainly could have gone through this chapter and verse in my brief if I had understood that the defendant was raising anything other than that he didn't get a hearing. But I do think, even in the context of not plain error, I think what we have here is a thorough district court opinion that considers all the relevant procedural history and understands the facts as presented. Certainly, this doesn't rise to the level of plain error in the context of procedural reasonableness. If there are
any further questions?
No.
Thank you.
Thank you, Your Honors. We would ask that you affirm the judgment below.
All right, counsel for appellant, we'll give you a minute or two.
Thank you, Judge Rogers. Ultimately, this is about disparity. That's what Congress said. That is why Congress authorized these resentencings. And despite what the government claimed.
Did you make a disparity argument in your opening brief? I saw something in your reply brief, briefly alluding to the problem.
No, I did not in the opening brief. It was in response because
okay, that's not allowed.
It is something that the district court didn't address. I'm correcting the government's comment. It said that
the district court didn't address it, and you think it's what this case is all about. It should have been in your opening brief.
Fair comment, Your Honor. Fair comment. But
counsel, don't give up too much. What about what you said on page 12?
Well, I mean, that is ultimately the issue, is that, this is all about disparity, and disparity is the one thing that is not addressed in the record.
Sorry, what on page 12?
I'm sorry?
On page 12 of your opening brief, you say, I'm quoting, assessing section 404 motions must take account of Congress's intent to rectify disproportionate and racially disparate sentencing penalties. End of quote. And you're citing White, the White opinion from this court.
And that is ultimately what this is all about. And that is not what
the remedy that you argued for. If we turn the page, the remedy that what you say we're supposed to do to address Congress's intent here is have hearings with elocution.
That is what Mr. Lawrence wants ultimately. And that is what we believe White calls for when it says full and fair hearing. We're having a hearing right now. There was no hearing in the district court. That's why there's no transcript.
Does the full and fair hearing have to include the defendant's presence to allocute, or are you arguing for the attorneys coming into court literally or virtually and having an argument before the judge?
We're saying that at least like a regular sentencing hearing has to have the judge offering the defendant the opportunity to allocute. He doesn't have to take it, but that Federal Rule of Criminal Procedure 32 would apply to these, and at least the opportunity. And given the fact that we do so much virtually now, it wouldn't be that difficult. We would not have to have the marshals bring him back to DC in the middle of a pandemic.
If we adopt your rule, it would apply going forward, and at least we're all hopeful that we're not going to be doing virtual hearings.
Right. But it could
longer.
still.
So really, this is a rule that would require prisoners to be transported, and sometimes district prisoners that could be halfway across the country here to allocate on a sentence reduction where they cannot have an increase in their sentence.
Correct. And I would also say, I mean, the other.
I don't understand, counsel. I mean, the Bureau of Prisons does these remote sentencing all the time. Judge Wilkins knows better than I. So, I mean, let's just be clear what your argument is. And I thought what Judge Millett was getting at was courts recognize that you can have, quote, evidentiary hearings on issues without the presence of a defendant physically.
Yes. And what I was thinking, without saying it when Her Honor asked, was, how long will the CARES Act continue? I mean, that is an option that presently we would have to say, fine, we'll consent to a virtual hearing. That way he can have his say, and he doesn't have to come all the way across the country.
Any further questions?
No.
Thank you. We'll take the case under advisement.
Thank you.
Case number 21-1071, Lisa Milice petitioner versus Consumer Product Safety Commission. Mr. McLean for the petitioner, Ms. Dixon for the respondent, Mr. Fee, amicus curiae for the American Society for Testing and Materials.
Good morning, Your Honors. May it please
Good
the
morning,
court.
counsel. You may proceed.
Good morning. I'm Jared McLean with the New Civil Liberties Alliance on behalf of Lisa Milice, the petitioner in this case. As an expectant mother, Lisa Milice tried to see the binding standards that govern the safety of the products that she was looking to buy for her child's nursery. But the Consumer Product Safety Commission, the agency tasked with assisting consumers in evaluating risk, only makes 2 copies of those safety standards available, both of which it keeps near its office in Bethesda, Maryland. And even for those citizens fortunate enough to be able to travel to Bethesda, Maryland, they are expected to memorize these intricate and technical safety standards because the commission forbids photocopying and otherwise disseminating the law.
So, counsel, would you address the jurisdictional issues?
Yeah, I'd be happy to, Your Honor. Since it's jurisdiction, we should start with the statute, and both the CPSA and the APA treat the terms promulgate and publication as distinct terms. I think ASTM's letter suggests that the terms are synonymous, except promulgate means the agency's formal proclamation that a rule is final and will take effect. It's the final agency action that that's consummated through the rulemaking process. That's the rule from Bennett versus Spears. A rule cannot be final for review until an agency has consummated the decision-making process. It must not be a merely tentative or interlocutory nature. It must determine rights or obligations or trigger legal consequences. And what the agency did here was use a direct final rule process rather than a formal notice of comment with a separate publication of a final rule. And
so are you addressing statutory timeliness?
Yeah, so under 2060A, an interested person, a consumer, has 60 days to petition from the date of promulgation. And our argument, Your Honor, is that there was no final agency action. There was no promulgation in this case until the effective date. And I know that's not typically the rule, but this isn't a typical promulgation. This was a direct final rule. And what the agency said in in its direct final rule was that the agency was proposing a rule and providing an opportunity for comment. And if one of those comments were adverse, the agency would pull the rule, because direct final rulemaking is typically used for uncontroversial rules. And in the event
let me just be clear, counsel. The reference that's in the Federal Register refers to a significant adverse comment within 30 days.
Correct.
And it describes what it means by a significant adverse comment. So it says, the commenter explains why the rule would be inappropriate, including an assertion challenging the rule's underlying premise or approach, or a claim that the rule would be ineffective or unacceptable without change. So 2 questions. 1, did your letter do any of that? And secondly, when did Mrs. Milice file a comment?
Well, addressing your first question first, Your Honor, our letter did suggest that there was a problem with the agency's rule that the agency still needed to address, because the agency—
Who's our letter? Who's R? Who's the R in our letter?
The letter was filed by my co-counsel in this case, by the New Civil Liberties.
On behalf of, did it say it was on behalf of Ms. Milice?
It did not, Your Honor.
No. It was done by the organization itself in its own capacity?
Correct, Your Honor.
Okay.
Except—
I thought Judge Rogers had asked you where Ms. Milice, I'm sorry if I'm not pronouncing her name correctly.
Milice, it's okay.
Milice, I apologize.
Uh-huh.
Giving her more Italian than I should have. Where did Ms. Milice file a comment?
Your Honor, Ms. Milice did not file a comment.
But we don't even need to deal with that rule about substantive comments.
Well, we do, Your Honor, because the agency put the public at large on alert that this rule would become final only if it did not receive adverse comments. So any member of the public who's looking on regulations.gov and following the rulemaking process would see that this comment was filed. And the only way to know whether the agency has considered this to be an adverse comment is through the agency's inaction. Some other agencies will file a confirmatory notice after the comment period to confirm for the public that there were no adverse comments. But the way CPSC structured its direct final rule was to say, if we have not filed anything else before the effective date, then we have not filed an adverse comment and the rule will take effect on the effective date. And so until that point—
Do you have any case where we applied the incurable prematurity doctrine to someone who hadn't filed for further consideration or reconsideration?
I do not, Your Honor. But I just point out that there's also no cases that deal with direct final rules, because direct final rules by their very nature remain tentative and are not final agency action until the agency confirms that it has not received any adverse comments.
Sorry, so does the agency here routinely then publish in the Federal Register, we didn't receive any material adverse comments?
So some agencies do, and the way that CPSC—
I'm talking about this agency here.
No, this agency only lets the public know through its silence if the agency has not filed a subsequent publication in the Federal Register by the effective date, then the rule will take effect as proposed. And I just point out, Your Honor, too, that under a construction that equates promulgation with publication in the direct final rule process, the public would be forced basically to choose between commenting or filing a preemptive lawsuit, a preemptive petition for review in court. And that's why we brought up the incurable prematurity doctrine, because the same principles apply here, in that I believe Judge Ginsburg pointed out that the purpose of the doctrine is to avoid needless litigation over agency action that is not yet final and might be mooted by a subsequent action by the agency that the agency has already been asked to engage with. And any member of the public who would go to regulations.gov would see that there's a comment, a multi-page comment raising serious constitutional arguments with the agency's practice, and would be
the process, but not challenging the substance of the standard at all.
Correct, Your Honor. But I'd point out, Your Honor, and the first argument in our brief is that it's very difficult to challenge the substance of the standard because the agency has not made the standard available to the public during the rulemaking process. And so anyone who wishes to participate is forced to go to a third party and purchase a copy of the standard. And they might also purchase a red line copy of the standard, which compares the proposed standard not to what the current binding safety standard is that CPSC has adopted, but instead compares it to a different ASTM standard that was never incorporated into law. So the arguments that were raised in the adverse comment were to process, but they were also to the public's ability to question the substantive
So
nature.
when did this become final in your view?
In our
If it doesn't
view,
publish anything else, how do we know?
in our view, that the rule would become final agency action when the agency had not published anything else by the effective date. So the clock would begin to run for judicial review on the effective date. And if you look at the text of the rule, that supports our theory, because the text of the rule says that the rule will not be deemed incorporated by reference into the Federal Register until its effective date. So the rule, by its own terms, remained tentative until the effective date and was not incorporated into the Federal Register and finally published until its effective date. And I recognize that this isn't the typical formal rulemaking process, but that there's a reason that direct final rules are not typically challenged in this court. And
Can you direct us to any time when our court or any court has said that promulgation is the effective date rather than the date of notification in the Federal Register?
Well, in this case, Your Honor, the dates are the same. There was the initial proposed rule that was filed, but that at that point it's just a proposed rule, and the rule actually becomes formally incorporated by reference on its effective date. So I understand Your Honor's question that in most instances there is a formal final rule published, and then there's a lag, and then there's an effective date that the agency might set 90 days or a year down the road, and you have to sue from the publication of the final rule rather than the effective date. But in the direct final rule context, on which admittedly, there is no case law on direct final rules. But in the direct final rule process, the way that CPSC has structured this specific direct final rule, the rule remained tentative until its effective date, and it was not incorporated by reference into the Federal Register until its effective date. So this is a bit of a unique circumstance in that respect, Your Honor.
Tell me what you mean by direct final rule. You mean just without notice and comment? Is that what you mean by that? Because
Yes.
it was definitely promulgated in the Federal Register and announced in the same way that a final rule would be after notice and comment rulemaking.
Yes. So the direct final rule process sort of collapses the notice of proposed rule and the final rule into the two steps that are typically, there's two publications, and the direct final.
In both situations, I just don't know how this is any more a direct final rule than an agency publication of a final rule after it has completed notice and comment rulemaking. We're at the same point. Congress just doesn't require notice and comment rulemaking here in this context. And so this context, just assume, at least, if you disagree, you can explain why later. Assume there's no notice and comment obligation here. This final rule is the same as any other final rule. I don't understand why it's more direct final rule and why that would change all these jurisdictions. I'm just not understanding why that changes all our precedent in the jurisdictional calculus.
Well, so in the direct final rule process, by its terms, the rule remains tentative and open to the agency. The agency says, if we receive adverse comments, we will pull this rule. And I direct the court.
Any case that is said when these things are published in the Federal Register, they're not a final rule, they're tentative for benefit purposes, they couldn't even be challenged until the effective date?
Yeah, so admittedly, Your Honor, there is no case law on direct final rules, and I direct the court to is a law review article that goes into detail.
Yeah, I got that, but you don't have any case law that's drawing this distinction that you're advancing to us.
I'm not, Your Honor, and I do not, Your Honor, and I'd suggest that that's because the direct final rule process is typically reserved for rules that are deemed by the agency to be non-controversial and they're not expecting public comment. And when there is an adverse public comment, the agency is required to pull the rule and engage in the formal rulemaking process. So there's typically not an opportunity for judicial review because if the agency follows the terms of the process that it sets out, the case never ripens for judicial review.
So your argument then, in a nutshell, I don't mean to misrepresent in any way, and correct me if I'm wrong, is that taking this direct rule process as the agency has described it in the Federal Register in September of 2019, the rule became effective December 22nd. And there was no way for your client to have provided any significant adverse comment because the rule itself was not sufficiently available to you?
Correct, Your Honor. I think I'd sort of separate that, parse that out a little more and say that the reason that our comments were limited to the unavailability of the rule was because the rule was unavailable. But I'd say as to the direct final rule process, our argument is that by the very terms of the direct final rule that was published by CPSC, when they published the rule, they said that this will only go into effect if we do not receive adverse comment, and we will let you know through our inaction that we have not received adverse comment. So there was no way for the public to know that there was final agency action until the effective date. And I think that's consistent with Bennett versus Spears, which says that a rule must not be merely tentative or interlocutory. And by its nature, this rule was interlocutory, and the rule specifically stated that it would not be incorporated by reference into the Federal Register, which would put the public on notice that this rule now triggers legal consequences. That did not happen until the effective date in this case. And I recognize that that's different than the typical rulemaking process. And Your Honor, I see that I'm well past my rebuttal time and into.
Well, you're trying to help the court understand this process. So I don't think we're holding you in that.
Yeah, thank you, Your Honor.
In 2056A, Congress itself says in this context where you're not challenging the substantive standard, underlying standard itself, your whole case is about an amendment to the standard.
Yeah, a revision, Your Honor. Yeah.
And Congress said it's going to take effect unless the commission decides that it doesn't improve safety. Right, so it actually makes things worse, not better. That's essentially, otherwise, the commission has no choice.
Correct. It will take effect.
Do you read this Federal Register language as defying this congressional command or putting into effect this congressional command? Unless we get a comment that shows that this is less safe, it's going into effect. Or you think they were adding something else in, unless you think it's less safe or you don't like the process, it won't take effect.
Yeah, Your Honor, the language that you're referring says that it'll go into effect if the agency determines that it's going to make things more safe after 180 days or a separate time that the agency publishes in the Federal Register, and the agency invites
the only basis on which they cannot let it go into effect that it's less safe.
Correct.
And there was nothing in your comments that was about less safe.
Our comments were that it's impossible for the public.
We don't know. Okay,
but we don't know.
That's not a comment that is less safe.
But that is a comment that is asking the agency to withdraw the rule and go through the
right. But they got a congressional command here that it takes effect unless it's less safe.
unless the agency sets a different date in the Federal Register. And
when they do that, they don't have to have it take effect for all different reasons. I would have thought this congressional, they could maybe have a different time frame, maybe a shorter one if it was urgent for public safety. But we're dealing here with a particular category of products that Congress wanted safety over everything and wanted the agency to move quickly. Your theory is that the agency could have said, oh, this won't take effect for procedural reasons. We won't have safer baby bath seats for 6 months or a year while we deal with this procedural issue? Do you think they have the authority to do that under the statute?
I think that reading the statutory scheme as a whole, Congress
have a duty to say do what I just said under this statute, to hold up on making bath seats safer for 6 months or a year while they address a procedural debate?
Oh, I'd suggest, Your Honor, that the procedural debate and the standard being available during the public comment period, the agency itself determined that public comment would help ensure that this.
I would just like a yes or no question. So you read this statutory language as saying safety will be cast aside and postponed if there's a challenge on another ground. It doesn't challenge the substantive safety. It may be a procedural one. You have a procedural one here, no doubt. That's your view of the statute.
My view of the statute is that I agree. I agree with Your Honor that the statute is designed to promote more safe standards, and the agency decided that by opening this up to public comment, it might promote more safety standards that are safer, and the public might have something to say. And our point was that there's no way for the public to properly engage in that process and ensure that these are the safest safety standards unless the standard is available during that process.
When did ASTM post the standard on its website?
After we fought, my understanding, Your Honor, is that ASTM has changed the structure and nature of its reading room after we filed our petition for review in this case, as the CPSC has also changed the nature of its reading room, in that it now exists, and if you do contact the agency, they do now seem willing to provide access to their Bethesda reading room, but that access is still limited to its Bethesda reading room. And that was all in response to this petition for review, Your Honor.
And Ms. Milice attempted to review this in the reading room or from ASTM prior to?
Correct, Your Honor.
On what date?
She contacted. Ms. Milice contacted exact date. It was in January at some point in preparation for.
It's in her affidavit.
It's in her affidavit.
Mm-hmm.
Yeah. And what she was told by CPSC was, we get calls like this all the time and we can't make the rules available because basically that's ASTM's intellectual property and they have to make money somehow.
But she didn't even contact them until after the effective date. She didn't contact them during the comment period, right?
Correct, Your Honor. But
So I mean, explain to me. I mean, we have a situation where she doesn't make a comment to the extent that she seeks to know what these standards were. She doesn't do so until after the comment period has expired and the regulation is now effective. So, why are we here?
We're here, Your Honor. I'd note that during the comment period, Ms. Milice would have been at the beginning of her first trimester and not exactly looking at infant bath seat safety standards yet. But
she doesn't have standing then.
Excuse me?
Sounds like she wouldn't have had standing. I'm getting very confused. You're saying that during the relevant time period, she wasn't injured because she wasn't thinking about baby bath seats.
When the comment period opened, she was pregnant, but she wasn't.
One can think about baby safety
and not be
the
pregnant.
first trimester.
Right. You're absolutely correct, Your Honor. But I'd note that the standing in this case is is conveyed on Ms. Milice through statute, which says that consumers are able to petition for judicial review of these standards that are promulgated by the agency. And under our theory, the rule did not become.
She doesn't claim to be aggrieved by the standard. She claims to be aggrieved by the process. And then it's a process that you're saying she wasn't actually yet interested in at the relevant time.
I understand your comment, Your Honor. And I think my response.
But go ahead.
Sorry, I understand your question, Your Honor. But my response would be that Ms. Milice was pregnant and was in the consumer market for consumer products during the rulemaking period, and she filed her suit within 60 days of the rule becoming a final agency action, as 2060 requires. And so she meets the statutory burden for standing in this case. If the agency were to have raised that Ms. Milice didn't personally file a comment, perhaps that would be a different case, but the agency did not raise that as a defense in this case. And that, I believe, would be a forfeitable argument.
If it's jurisdictional, of course, we have to raise it ourselves. You agree with that?
If what, Your Honor?
If it's jurisdictional, we have to raise it ourselves.
I agree with you, and that's why I'm suggesting to the court that under the statutory jurisdictional requirement, Ms. Milice does qualify. And if there was some quibbling about whether or not she personally filed an adverse comment in this case, it was incumbent on the agency to raise that.
Okay. And now that she can see it online for free now, and this isn't a damages action. And I haven't heard that since it's available online for free now, that she has identified substantive concerns with the safety of the standard. So what remedy are you seeking? You ask us to get rid of a rule that makes bath seats safer because of a process that she now knows wouldn't have changed. She doesn't claim, at least doesn't argue, would change her view of whether this rule should have gone forward because it makes bath seats more safe.
Your Honor, Ms. Milice would be satisfied if this court kept the rule in place but remanded for a rulemaking process with the standard open to the public and required that the agency.
But it's open. She can see it now, free online, and so.
Well,
I don't know what remedy we're supposed to provide.
Your Honor,
because she doesn't say that had I look. I didn't see any argument in your brief that had I seen then. And had I been interested then in what I see now, I would have made X, Y, or Z comment. I see no prejudice argument. I see no argument that anything would have changed whatsoever. And you argue for vacature. You're now abandoning that, I take it?
The reason we were arguing vacature, Your Honor, is because we believe that we couldn't know whether this is what would be the safest safety standard without the rule being available to the public during the notice and during the commenting process. And the purpose of the commenting is to promote robust and diverse comments, to protect the rights of the consumers, and to develop the factual record before this court reviews. And we weren't able to have that happen in this case. And so that was our idea, but we do recognize that we do recognize the problem with vacating the rule entirely and not having a safety standard in place.
Not vacature, I'm still not, because again, the rule is available free online.
Oh, sorry, Your Honor.
I haven't heard, I didn't see in your briefs, and I haven't heard today, but maybe you want to tell me now, any substantive objection to the bath seat standard with a, had I known then and had I been interested then, you said she wasn't, but had I been interested then and had I known then what I know now from looking at the free online version of the standard, here's what I would have told the agency to make bath seats safer.
So I guess the point that I skipped over the last time, Your Honor, we do not believe that The standard still is not available for free online because it's available through ASTM's reading room only. The agency itself has not made the standard available for free online, and there is no legal mechanism requiring ASTM to keep the standard online for free in its reading room. And
has she or you as her counsel looked at the standard?
I have, Your Honor.
Okay. And you're her attorney, so you can describe to her and advise her if there was something about it that was unsafe, some argument for her to make.
Yeah, Ms. Milice does not personally have a substantive challenge to the safety standard itself. Mrs. Milice is
even aware of now that she could look at this online for free.
Correct, Your Honor. And Ms. Milice's position is that the safety standard would benefit from being publicly available because it would open it up to robust public comment. And by keeping the law hidden, and it's doing a disservice to parents and children who are looking to buy these products, because we can't be certain that these are the safest standards that we could have.
Well, that's not what's going on here. There's a technical amendment by ASTM. The statute tells the CPSC what to do with that. If she thinks they could be even safer than this, she needs to petition for rulemaking. Right? This isn't it wasn't an open-ended comment period. It's like, here's a new change in standards by ASTM. We think it doesn't make bath seats less safe. Makes it more safe. So we're going to go forward with it unless someone tells us it makes it less safe. And it sounded to me like your argument now was, well, you know what? We don't disagree with that, but these things could be even safer if you open it up to public rulemaking. That sounds like a petition for rulemaking is needed to me.
At the core, Your Honor, Ms. Milice's argument is that binding safety standards need to be publicly available both during the rulemaking process and after promulgation. And without access to the law, the public is deprived of its right to see the law, its right to disseminate the law, its right to argue for more stringent safety standards. It's the whole plethora of rights that come along with
just
the
kind
right.
of a going forward, the agency should comply with what she would say the Constitution and statute requires. Going forward, the agency should comply with the law. That's her interest?
Correct, Your Honor. Mrs. Milice's interest is within the agency not relinquishing its control on the law. Ms. Milice believes that the CPSC needs to make its binding safety standards publicly available in the way that all other law is publicly available. The CPSC, the FOIA amendments to the APA, the Federal Register Act, all of these laws were put in place to promote more public access to the law, and they cannot be read in combination to somehow create this exception that allows the agency to hide its law behind a paywall.
All right, so why don't we hear from the agency, and we will give you some time on rebuttal because we took up a lot of your time on these threshold
Thank you, I appreciate that, Your Honor.
Issues of concern to the court. All right, counsel for the agency.
Good morning, and may it please the court, Courtney Dixon for the Consumer Product Safety Commission. I'll start with the jurisdictional question that the court has asked about. With respect to the incurably premature point, Your Honors are correct that it was NCLA who filed the comment to the commission. It was not Ms. Milice herself or NCLA purporting to act on her behalf. And this court has made clear in its case law that the incurably premature doctrine is a party-specific doctrine. It's a timely objection to an agency rule renders that rule non-final with respect to the requesting party. So Ms. Milice herself could not take advantage of that doctrine to save the rule from untimeliness. If there are other questions on the jurisdiction point, I'm happy to address those.
Well, what do you do about the Federal Register thing, which seemed to say, unless we receive a significant comment?
So, Your Honor, this court's
effect. And so if you get a significant comment, is the rest of the world to think it's now a non-final rule and we can't file a petition even though we didn't file the comment? Or is it specific to the part? It's a little bit unusual, normally reconsideration.
So
It's not framed like this.
there's two responses to that. I guess first, with respect to this court's case law, and then I'll respond to some of the petitioner specific arguments in this regard. First, this court's case law states that the default rule is that a rule is promulgated on the date that it is published in the Federal Register. And here that happened in September 2019. And indeed, petitioner herself in her petition for review and in her brief describes the promulgation date of the rule as September 2019. This court has explained that statutes and regulations can, set a different promulgation date outside of the default rule, but there's no statute or regulation that does that in this respect, and petitioner hasn't identified any. So, under this court's default rule, the best argument for, or the best answer for when the rule is promulgated is the date it was published in the Federal Register, this September date. And as Your Honor's questions earlier reflected, I'm not aware of any cases in which the effective date of the rule is seen as the date of promulgation. With respect to the question
so let me be clear. What does that mean as to anyone who wants to challenge the rule? That's what I'm trying to understand. You're saying it took effect in September.
It was promulgated in September, Your Honor. It took effect in December. And Your Honor's question—
I understand that, but I want to understand what the significance you attach to the promulgation date.
Certainly, and I think this perhaps goes to Judge Millett's question as well, and then some of the things that petitioner was saying in his presentation. At the time that the agency published this rule in the Federal Register in September, the agency said, ASTM has revised its standard. These are our procedures for considering revised standards. These are the changes that ASTM has made to its standards. It summarized those changes and explained its findings that these changes either improve the safety of infant bath seats or they're new.
Okay, I understand the agency said we're invoking the good cause exception, okay? But then it goes on with this paragraph to which I alluded in questioning counsel about this significant adverse comment. So what does that do to the promulgation of the rule?
Right, so in that Federal Register notice as well, Your Honor, the agency explained that it was going to incorporate ASTM standard by reference. And then it said, this is going to take into effect in December unless we receive a significant adverse comment that, calls into question this approach. There is, the public can have it say it if it wants. We've explained our process. So at that time, take petitioner herself.
Let me just say, counsel, with all due respect, it says unless we receive a significant adverse comment within 30 days, the rule will become effective on December 22nd, 2019.
Yes, Your Honor, and that's the effective date of the rule. And if petitioner—
And so what is the significance of the September promulgation? That's what I'm not clear from your argument.
Right, so that's when the agency published its rule.
It gave notice. Here's what our rule is going to say.
And it explained its reasoning, and that would become the final rule of the agency unless the agency, withdrew that and then would proceed, presumably depending on the significant adverse comment, if the agency could, depending on how it fit with its substantive rules, the agency could—
Okay, I just want to be sure we're talking the same language. So it publishes notice of its proposed rule in September, all right? And it says it's going to take effect in December, unless. So the key date here is the December date, is it not?
That's the date that the rule was set for, the effective date of the rule, Your Honor. But again, the promulgation date, the date that this rule was published in the Federal Register, was the September date. And this court has stated, that is the presumed date that a rule is in fact promulgated. And
what do you think that means?
It is when the rule, just like a final rule, would be published in the Federal Register. And
You're
then
using the two terms as synonymous, and I'm suggesting that at least based on what the agency put in the Federal Register, it drew a distinction.
Your Honor, it's not infrequent that the agency—
I'm not suggesting it's frequent or infrequent. All I'm talking about is this rule. And in my view, this is complicated enough without equating promulgation and effectiveness.
Well, Your Honor, I guess what I was going to say, it's not infrequent that an agency will publish a final rule and then set the effective date of the rule to be any amount of days in the future to then provide the public—
Irrelevant. That's all I'm trying to say, counsel, is that's what the agency said. Now tell me how it works in this situation. All right, counsel has said, we read this too. But it's impossible for us to do anything in accordance with what the agency wants because we haven't been able to see the rule.
And
Excuse me.
And I would disagree in several respects, but I guess I'll just say, if Ms. Milice was to look at the September date, the September rule that was published in the Federal Register, which was titled Direct Final Rule. Again, it explained the changes, the commission's process. It explained that the agency was going to incorporate it by reference. And it set out, again, its reasonings for all of that. Had Ms. Milice thought, hey, this standard needs to be published itself, ASTM standard needs to be published itself in the Federal Register, which is her merits argument here. And I can't provide a comment because it's not published here. Then Milice could have submitted a comment to the commission. I mean, NCLA submitted one to the commission, and then there might be a question of whether, that comment submitted within the 30 days rendered the rule non-final as to her. Of course, she can't take advantage of that because she didn't file a comment. She had all of the information she needed before her at that time to file the challenge she's filed right now. Again, her merits argument is that in September, the agency needed to have provided the full text of ASTM standard itself online. She could have made that exact argument in a petition for review filed within the 60-day window. So she could have filed a comment, she could have filed a petition for review. What she couldn't do is what she did here, which is to just stay silent for 5 months and say, hey, I'm really interested in what the agency is doing here. I think it's wrong. I want it to change its mind, but I myself am not going to see or do anything. And so I think that's the situation that we're in with respect to the timeliness of her petition.
But how does a comment, to follow up on Judge Rogers' question, how does a comment, I'm trying to understand the interaction between your language in the Federal Register and 2056A, 2056A, B, how am I going to get this? B,
Your Honor.
or B, the statute. As I read the statute, it says, there's already a standard adopted here. That's water under the bridge. They can't challenge that. This is just some amendments or updates were made to the standard. So the baseline standard is not an issue here. It's just these updates. And when there's updates like that, they go into effect at pursuant to congressional command within 180 days, unless the commission finds, could do it based on a comment or on its own, that it makes things less safe. So Congress here, and there were listed categories, the expedited judicial review ones, and ones where Congress was most urgent about things that will make things safer going into effect immediately and nothing getting in the way. But then your Federal Register notice seems to say the rule would be inappropriate, including an assertion challenging the underlying premise or approach. And so you were just talking about, had she filed an objection that said your approach makes, I can't tell if it's more safe, less safe, or the same because of your approach by incorporating by reference and not telling me what the standard is. Is it your view that had she filed something like that, using your approach language from the Federal Register notice, it would have made the rule no longer final and Congress's command about effectiveness would have ceased to apply?
I think that there would be a question at that point whether the incurably premature doctrine applies in this context. Of course, we're not dealing with that question here because Petitioner herself did not file a comment. I think that Your Honor's question is getting at kind of the reasons why the commission did reject NCLA's comment here and did not consider it a significant adverse comment, because the comment that and didn't withdraw its rule and let the rule go into effect, because NCLA's comment said, hey, you shouldn't use these private voluntary standards that are, behind a paywall, as they characterized it, and you should publish it in full in the Federal Register. And the commission said, well, one, we're constrained to use ASTM standards at this point, so you're not taking into account our substantive requirement under the 2056A B4B language that Your Honor read. Mm-hmm. And then there's the secondary point of also, we're allowed to use incorporation by reference, and the NCLA's comment hadn't fully taken into account the incorporation by reference procedures. And so the commission determined that NCLA's comment was not, in fact, a significant adverse comment that would have required it to withdraw its rule in light of Congress's command in the statute.
But how this
I
works
think-
is if someone had, I'm sorry, finish your sentence, I apologize.
No, I was going to say it's a little bit of a counterfactual, perhaps, to know if someone had filed a comment saying, questioning, I don't think that this improves the safety of infant bath seats, or I don't think that you should be using ASTM standard at all. Like, the commission may have considered some of those not significant because of it's not matching the statutory standards. The commission might have considered them and taken a different approach. It's a counterfactual to know, but in this circumstance, NCLA's comment didn't change the rule that the commission had promulgated.
And just to understand how this whole thing works, if someone had come in and filed a comment that said, wait, just assume a hypothetical change, you're increasing the size of the circle where the legs go through, and now I think it decreases safety because now a baby's head could get stuck in that hole or something like that. So you get something that is addressed to substantive safety. One, does the agency, because you had said before, make it not final as to her, would a comment like that make it not final as to, say, that manufacturer, or would it make it non-final as to everybody, or would you withdraw it to study, or what if you just didn't agree because that had been tested for? I'm just trying, how does it work if you actually had something that was talking about the measurements itself, their safety?
Right, I can't say for sure because here there wasn't as
Well, but you represent the CPSC, and surely it's happened that someone has filed a comment that addresses safety. Is that not, maybe not, you don't get them?
I can't speak with respect to ASTM standard as it's been incorporated with respect to this particular rule. I'm not aware of a circumstance because the agency has.
I'm not talking, I said a hypothetical, just because I don't want to suggest anything about ASTM's rule one way or the other. That's not my area of expertise. I'm just saying if there's some standard that's adjusted and a manufacturer thinks this makes it worse, not better, what happens then? Because you had said before, had you filed a comment, it might make it not effective as to her, which makes me think that if someone files a comment, it just suspends the application of the rule as to that filer.
Again, it's hard for, I don't know how that would play out in practice, and it might, if
the commission has never gotten under this rule, not under this bath seat rule, but under the statute here, it's never gotten a comment that says that makes it less safe, not more.
I am not aware of a situation. That's not to say it hasn't happened. I'm saying that I'm not aware, and I also don't know how it would play out in this particular context where you have the specific infant bath seat standard. Again, there's a specific process prescribed, and a version of ASTM's bath seat standard has been incorporated as the commission standard for over 10 years. There have been at least 2 other circumstances in which the commission updated ASTM standards through the process that we've been discussing. Had a manufacturer said, you're wrong about your evaluation of this standard substantively, it doesn't improve the safety of infant bath seats, I imagine the commission would take that seriously and might reconsider its approach. I can't say for sure.
Files a substantive comment. Let's say it's one that complies with the terms here. Is that a matter of public record that all of industry would know that's there and the standard isn't going to take effect, or is how are they? Would everyone know? How would someone know?
It might be on the rulemaking docket. I'm not certain, Your Honor. But there's a 30-day comment period, and of course, again, had the commission received a substantive standard calling into question the safetiness of infant bath seats, the commission would have taken it seriously. But again, in the circumstance we have here,
the public record comments.
I'm sorry.
The comment period comments are all on a public record.
I'm not certain for sure. They might be on a public docket, but I'm speculating. I don't know, Your Honor. But again, here with respect to Ms. Milice, she didn't submit a comment. She didn't file her petition within 60 days, and the comment that NCLA submitted, doesn't change that. I'm happy to address the questions on the merits. As we explained in our brief, the standard is reasonably available here. The APA's incorporation by reference procedures were followed, and petitioner's argument that in order to be reasonably available, something has to be posted for free online by the commission is not compatible with the statutory requirements.
You
and
know
is
when
not-
it was posted, when it first became free online by ASTM, what that date was?
Your Honor, it's not reflected in the record here. My understanding from the agency is that it was posted in ASTM's reading room in January 2020. That was before the petition for review was filed in this case.
But after the effective date.
The effective date was December 22nd, Your Honor, and it was January 2020 when it was posted in the ASTM's online reading room.
So during the comment period, unless you had the financial wherewithal to pay for the standard, you couldn't see it. If you're a member of the public, you couldn't see it because if you don't have the financial wherewithal and you don't live in DC or the MDVA area.
It was available for inspection, you know, in the DC area. And
Well,
then,
if they can't afford the money to pay for the standard, it may well be that they can't afford a plane ticket and a hotel into Washington, DC to come look at it.
and Your Honor, the incorporation by reference requirement, for one, it takes place, it's whether something is published in the Federal Register for purposes of the effective date. There's not a requirement from OFR that something be, that all the incorporation by reference standards be met even at the proposed rules making stage. Certainly the agencies across the federal government and the CPSC.
What? I'm very confused here. The September publication of the final register was not proposed rulemaking. That was announcing the final rule.
Certainly, I guess I mean the effective, it wasn't available prior, the fact that it wasn't available prior to the effective date, Your Honor, I guess is what I'm trying to say. But
Well, I think supposed to comment if they can't see it.
Well, first, Your Honor, I mean, with respect to this case here, petitioners, you know, haven't identified any
I'm
substantial.
just asking you how the commission thought this was going to work.
Well, Your Honor, again, a version of the ASTM standard has been incorporated as
I thought how the commission thought in September 2019 this was going to work.
Your Honor, again, ASTM standard has long been the commission standard, and manufacturers have been using this standard. Manufacturers certainly are
I thought from the statute that consumers and the public had an interest, but I take it no.
And they do have an interest, Your Honor. And again, there's not any suggestion here that a consumer had an objection to the substantive requirements of
They
ASTM.
couldn't see it unless they lived in this area inside the Beltway.
I also don't know, Your Honor, there's no suggestion that a consumer couldn't see it. Petitioner herself didn't try to contact the commission to inspect.
You tell me how, I just asked you how the commission thought this was going to work, and I can't get an answer from you. How did the commission think a consumer that loves their baby as profoundly as can possibly be, but doesn't have a lot of resources and lives in California, Arkansas, Nevada, pick your state, Montana, how were they going to comment?
So I guess I'll back up, and I apologize if it was seeming that I was avoiding your question. I want to emphasize as well that when the agency published its direct final rule in September, as I noted earlier, it quoted the changes that ASTM had made to its standard. It described those changes with some detail, and it explained its findings of how it believed that those standards improve the safety of infant bath seats.
Does your explanation make any sense to someone who doesn't have the underlying standard as well?
You know, I mean, I guess it's a little hard to know what would have necessarily made sense in the sense that this is a technical manufacturing standard that's supposed to be used by manufacturers to manufacture bath seats. The agency, for example, quoted some things that are certainly understandable to a consumer. For example, the agency quoted in full some wording changes that ASTM had made with respect to its label to say, you know, to use more direct language of stay in arm's reach of your baby as opposed to keep your baby in arm's reach. Those changes are quoted in full. There are quoted definitions of
tests that were conducted.
I'm sorry?
Are the tests that were conducted described? I don't know how you can know if any of this is relevant. You don't know how it was tested.
I guess by tests that were conducted, I'm not sure exactly what you mean, Your Honor.
A description of a bunch of technical mumbo jumbo without any sense of what was tested, how it was tested, what these numbers mean, or even what the underlying standard is, seems to me.
I guess we're
for consumers.
You're in the context, Your Honor, of the 2056A B4B of these are the revisions that ASTM has made to a standard that's already incorporated into law. And we're looking at these revisions and determining whether they we can't accept these revisions unless they do not improve the safety of infant bath seats. And so the commission then was quoting the revisions and explaining the revisions and how the revisions would add clarifying information.
I can't tell from reading the Federal Register. I look at that and I can't tell what's going on to make any informed judgment about whether safety is improved just by reading that without having any idea what the underlying standard is, what kinds of tests were applied, and deciding what changes to make or not, what tests weren't done, any of that.
Well, the commission explains, for example, that, and I think it probably depends on the nature of the changes as well. And that if, for example, here, the commission says that wording was moved from an explanatory parenthetical into enforceable testing requirements. So something that was just prior in an explanation is now more clearly set forth in the test itself. So it's more clear to manufacturers who are making this, what is being, why you're conducting the test, what needs to be done. That's explained. I think, for one, if you're a manufacturer, you most likely possess a copy of this standard, you already own it, and you're going to understand.
No, I'm talking about consumers here. I'm not talking about manufacturers.
And a consumer, again, could have accessed ASTM standard at the commission's headquarters or purchasing it. But I think, it's a technical manufacturing standard that's intended for manufacturers to be using in manufacturing bath seats. And I think it's telling, Your Honor, that again, petitioner herself has not identified any critical comment that she would receive. There's no indication from any consumers of a critical comment that they would have provided had they had the supposed access to the standard that they say was required. And certainly within the context of this case and petitioner's 553 challenge, even assuming that it's correct that there wasn't the adequate provision of the standard that she says is required, which again, we don't think is correct, she hasn't shown error, and that's a requirement for this kind of 553 claim. So with respect to this case, Your Honor, it's significant that she hasn't, again, identified any such comment. And I think it maybe belies the assertion that there hasn't been adequate notice, that there isn't any such comment even proposed that someone would have provided.
All right, thank you.
Thank you.
So, counsel amicus curiae.
May it please the court, Kevin Fee on behalf of American Society for Testing and Materials. I thought in light of all the court's questions about jurisdiction, it might just make sense for me to start with that for a minute or two. From ASTM's perspective, we see this as a relatively straightforward timeliness problem. The petition for review concedes that the direct final rule was promulgated on September 20th, 2019. And section 2060 G2, which is the jurisdictional provision at issue here, says that a petition must be filed, quote, not later than 60 days after promulgation. The petition here was filed on February 20th, 2020, and that's not within the 60-day window after September 20th, 2019. And so it's untimely for the court to consider the petition, and this court lacks jurisdiction over this petition. Now, very briefly, the NCLA's argument and petitioner's argument, as far as I understand it, is that their letter constituted something that was effectively requesting reconsideration of the direct final rule.
So could I be clear, counsel, your position then would be, or would it, that what was published in the Federal Register was contrary to the statutory scheme? In the sense that it talked about this significant comment within 30 days.
I don't think that that's contrary to the statutory scheme. If there was a significant comment that, as Judge Millett was alluding to, indicated that the safety standard was not, in fact, safer than the prior standard, then I presume the CPSC would have withdrawn the rule. But it was a final rule when it was promulgated in September of 2019.
Well, you're saying, as I understand it, she would have to file a petition within 60 days of the September date.
Yes, Your Honor, that is our position.
And the way you're reading the Federal Register announcement is the commission would have received comments before then and could determine whether or not there was a significant adverse comment.
The commission could have done that, Your Honor, yes.
Just trying to understand how the process works, counsel.
Yeah. So my understanding of how the process should work is that the direct final rule was in fact a final rule as of September 20th. If anybody wants to challenge that rule, at least preliminarily, there could have been two avenues they could have gone down. They could have filed a letter that they claimed identified a significant adverse comment, or within 60 days, they could have filed a petition with this court. Here, the petitioner did neither of those things. The petitioner did not file a letter suggesting that there was a significant adverse making a significant adverse comment, and it did not file a petition within 60 days of the promulgation of the rule. So unless you, one last point I want to make on that front is I didn't allude to the fact that petitioner claims that her letter, or really her counsel's letter, constituted effectively a request for reconsideration of the direct final rule, and therefore it's the petitioner's time to file its petition should have been extended. But that's the reason we identified the Laminator Safety Glass Association case to the court in our letter addressing jurisdiction, because that case, the DC Circuit made clear that there is no reconsideration mechanism under Section 2060. And so reconsideration petitions cannot extend the 60-day time limit. So we think that the DC Circuit's precedents are clear on this point, that there is no basis for extending the period for filing the petition.
And in that case, there was no process such as described here in the Federal Register. And that's why I asked you whether or not you thought it was contrary to the statute. And you thought, no, it was, as I understood your answer, it was compatible with the statute.
That's right, Your Honor. So unless there are any other questions on the jurisdiction.
So, can I just be clear? Do you not understand that to be a process for reconsideration? It's a 30-day window. So if you get an adverse comment, suppose, someone filed saying, by enlarging the size of the hole here, a lot of babies' heads will get stuck because heads are generally smaller now than they used to be 10 years ago, something like that.
Sure.
So the commission is saying, yeah, if we get that, and presumably we think it's, got some reason to explore it, then we'll pull the rule off until we can examine it.
Sure, the commission could have done that, certainly, Your Honor. But even if you analogize the period for having a significant adverse comment filed to a request for reconsideration, the Laminator Safety Glass Association case makes clear that any potential request for reconsideration under the CPSA would not extend the 60-day time limit for filing a petition with this court. So turning to the...
Oh, go ahead. No, go ahead. What did you want to turn to?
I was going to turn, Your Honor, to the merits of this, unless you had any other jurisdictional questions.
To the what?
To the merits of the case.
Okay. Well, if someone, I'm still trying to understand, and maybe if there were a substantive safety standard, like the baby's head could get stuck in the now bigger leg hole, what would it? You said the agency could, but what I'm trying to understand is what happens. That's filed. Let's assume it's filed as a matter of public record. I guess we don't know, but let's assume it is. Once it is, does that mean, and let's assume it's filed by a consumer, not by a manufacturer. What happens then? Because the agency presumably isn't within minutes going to decide what to do. So the agency is trying to figure out what to do and thinking about this. And let's say that comment is filed the last day for comments. So it's timely, but now we got a closer window to the effective date. Effective date's approaching and the agency still hasn't said anything one way or the other. What does that mean? It's not effective. It's not effective when there's something like a comment like that is lobbed in, unless the agency says something. We should assume it doesn't meet the standard and it will go into effect. And if, changing my hypothetical, it was filed by a manufacturer, would it just become not effective for that manufacturer, like petitions for reconsideration usually work, or would it be for the whole industry? I just don't know how it works if you actually have a substantive safety comment.
So what I would expect to happen in that circumstance is the CPSC to evaluate whether or not the comment actually raises a significant adverse issue. And if it did, it could withdraw It's
Well, that
notice
takes some
filed.
time. So they're sitting there studying and I'm trying to figure out whether I need to get new equipment in, rejigger my existing equipment to manufacture this thing. I didn't make the comment. What am I supposed to do?
Well, Your Honor, if you're a manufacturer and you have a concern like that, I believe you should make a comment and or file a petition with this court.
Well, I was going to, and I saw someone already lobbed it in, so it's there. My
Well-
comment's already been made. What do I do?
Yeah, I think that gets to the point that you were talking about earlier, Your Honor, that to the extent that you consider what a letter that purports to be a significant adverse comment to be analogous to a request for reconsideration, the incurable prematurity doctrine only applies to the party who made that request. And so if you were another manufacturer that had a safety concern, I would expect you to either file your own letter identifying a supposed significant adverse comment or file a petition with this court.
And I just had a question about your license agreement.
Sure.
It says that someone who's going to look at this free online version cannot exploit any of the material contained on this site in whole or in part without the express authorization of ASTM. So if a consumer were to look and a consumer were to have a serious concern, and let's change it because I don't want to, let's say it's a different standard company. It's not your client. It's company X that makes their standard creating company X. And I'm deeply worried about what standard, now that I've looked at it online, checked all these boxes, I want to put a comment in because I'm deeply worried about what standard creating company X has done here. Is that exploiting the material? And so they would have to have the permission of, assuming they have the same license agreement you do.
Right.
You would have to have the permission of the company to make that comment.
I absolutely
What
don't
does
think
exploit mean?
that would be exploiting in the context of that license agreement.
What does exploit mean in you? And can you tell me what exploit means in your license agreement?
I would
Is
say
that
exploit
license
means to exploit in a commercial manner is what the license
Doesn't
agreement
say
is
that.
referring to.
It's
Well,
in any way exploit.
Right. And Your Honor, I think another important point maybe to make on this front is to the extent that any agreement such as terms of conditions of conflicts with the fair use requirements, for example, there is preemption that to ensure that.
I'm sorry, counsel, having trouble hearing you.
I'm sorry, Your Honor. There's a preemption doctrine that provides.
Okay, so I'm a simple consumer. I don't know copyright law.
Mhm.
And I just read this in any way exploit. And I'm going to have to take, and I want to tell the CPSC as soon as possible that I think there's a real problem with this company X's standard. And I'm supposed to know that exploit has to be interpreted with the fair use provision. And so it
Yeah.
doesn't mean commercial use.
Your
And you all
Honor,
can make this a lot clearer.
fair, Your Honor. I think that there
haven't.
probably is room for improvement on some of the language in the license
Certainly.
agreement. Realistically, just so the court has the context, that license agreement, ASTM doesn't enforce against consumers ever. What that is there for is to ensure, for example, that there's.
I'm not going to know that as a consumer reading it.
Yeah, I understand that, Your Honor. You're right. But I guess it's possible if a
If they
consumer.
really want this to be free online, they might want to do a real careful read of that license agreement because there's a lot of stuff that would scare even me off, let alone less informed consumers.
That's certainly not the intention, Your Honor. That license agreement is really only there for.
Not really free if people feel like they're going to get in trouble. They can't either use it for what they want to use it for, or they feel like they have to agree to a lot of standards that are going to sound pretty onerous to them in the process.
That's fair, Your Honor. The reason that's there is to prevent foreign entities from making unauthorized copies of these standards and selling them
Those are
online and
completely
providing a
legitimate
jurisdiction.
concerns. Those are completely legitimate concerns. It's just not how this license agreement seems to be read, at least to the layperson.
Fair enough, Your Honor. But really, at the end of the day, Your Honor, I think what the petitioner's argument wound up at was it is asking this court to adopt a rule that federal agencies must publish thousands of privately authored standards that were admittedly copyright protected without the copyright owner's consent, based solely on the fact that a federal agency such as CPSC happened to incorporate the privately authored work by reference.
Can I ask a factual question?
Yes, Your Honor.
When did the ASTM become aware of the comment that was filed by the NCLA in this case.
Your Honor, I don't believe that ASTM became aware of that comment until after actually the petition in this case was filed. We didn't learn of this petition even until I believe May of 2020.
So when comments were made, was there a process in place for ASTM or anyone to go onto the commission's website and see the comments kind of as they were coming in?
I don't believe that ASTM certainly has a forum where parties can see the comments that were made by others in response to rulemaking. What ASTM does as a policy with respect to works that are incorporated by reference by the federal government is they work with the agencies and are willing to put them available on their online reading room even before they're incorporated by reference during the comment period, so that the public has easy and free access to review those in connection with the rulemaking process. In addition, once they become effective, ASTM has a process in place to make those works available online in the reading room going forward while they're, once the ASTM becomes aware of the effectiveness of the regulation that incorporates their work by reference.
That's a new policy. That wasn't in effect here.
But Your Honor, that actually,
I'm just asking, this is just a yes or no question. That's
no, but the answer is no, that is not a new policy.
how come it wasn't posted free online until January?
Well, the reason it wasn't posted online during the comment period was because the way that the system works is the federal agencies notify ASTM of their intent to incorporate by reference an ASTM standard. And once ASTM receives that notice, it then puts the standard issue in its reading room. For whatever reason, the CPSC in this particular instance did not notify ASTM of its intent to incorporate this new work into a rulemaking final rule until, well, never did actually. And that's, I think, as we alluded to in our brief, we've now worked with the CPSC to ensure that that process is followed going forward.
So normally you get notice from agencies, and there was just some sort of glitch in this case.
That's correct, Your Honor. And it's long been the policy of ASTM as well to ensure that works that it becomes aware of that are incorporated by reference by the federal government are available online for free during the time frame that they are, incorporated by reference in any standard or into any regulation. So realistically, there should not be, and I don't think really ever is, a real problem with persons getting access to these standards. One other point I want to just make.
I just asked, so in this instance, for example, in September, the standard would have been available on your website, your client's website?
The standard would not have been available in the free online reading room in September because the CPSC did not notify ASTM of its intention to incorporate that standard at that time.
Okay, but had it notified, then
yes,
it would be. That's your representation.
Yes, Your Honor. That is the process that ASTM has in place with the federal agencies that incorporate its standards. So getting back to the petitioner's argument, it finds no support in the Copyright Act, the Freedom of Information Act, or the Constitution. In taking this drastic step, requiring all these standards to be published online by the CPSC without restrictions would dramatically undermine the private standards development ecosystem that Congress sought to advance when it enacted the National Technology Transfer and Advancement Act. And as a result, we believe the petition should be denied. Petitioner attempts to rewrite the Copyright Act and alter the decades-long private-public partnership based on her claim that a single ASTM standard was not reasonably available under the Freedom of Information Act. But the Office of Federal Register has consistently found that ASTM standards are in fact reasonably available, including the standard issue in this case. And that's hardly surprising because anyone with access to a cell phone or internet access can easily access the standards at issue almost instantaneously and for free. In addition to the online reading room, ASTM makes its standards available for purchase at reasonable prices, ranging from $35 or so up to approximately $80. This goes far beyond what is required by the reasonably available standard. The plain language of reasonably available does not require the government to provide unlimited and free online access. The term reasonably available does,
How often do you update these types of standards? Does that tend to be like kind of a yearly thing? More
no,
frequent?
Your Honor, I think that as soon as we receive notice of either an intent to incorporate a standard by reference or that a standard has been incorporated.
No, when you're developing the standards, how often are you?
Oh, I'm sorry, I misunderstood your question,
Updated.
Your Honor. That depends on the committee.
Technology is always changing.
Yeah, that depends on the committee, Your Honor. I think that frequently it's 2 to 5 years would be most standards are updated.
What about baby bath? Had it been 2 years since you've done a baby bath update?
I think it was actually less, Your Honor. I think there was a 2018 update and then a 2019 update.
Okay.
So getting back to the plain language of the Freedom of Information Act, reasonably available does not mean available for free. The ordinary meaning of reasonable includes the possibility of a non-zero expense. Still less, reasonably available does not mean available for free online and without any restrictions on its use. No regulation could have met that condition when the Freedom of Information Act was Section 552 was enacted in 1967. Petitioner attempts to avoid a finding of reasonable availability by arguing that this court can only consider availability directly from the CPSC. But Section 552 of the Freedom of Information Act does not say that. It only requires that the works be reasonably available, and it does not limit the availability to the agency incorporating the work by reference. As a result, petitioner is wrong to assume that ASTM's considerable work in making its incorporated standards widely available should be disregarded by this court. As I mentioned earlier, ASTM standards are much more widely available now than any standard or regulation could have been back when Section 552 was passed. And under any credible interpretation of reasonable availability, the standard issue is reasonably available.
All right. Thank you, counsel.
Thank you, Your Honor.
All right. Counsel for petitioner.
Thank you,
A
Your
couple of minutes.
Thank you, Your Honor. I appreciate it. On Counsel for ASTM's last point, our position is that to be incorporated by reference into the Federal Register, it's deemed to be published in the Federal Register. It must be published elsewhere, and our position is that that publication elsewhere must be done by the federal government or otherwise within the public domain. The law, we've suggested free availability online because to us it seems like the most efficient and cost-effective way to do so, but if the agency were to instead just make the law available the way that all other laws are available, that would also satisfy the standard. In places where Congress has allowed for cost to access the law, Congress has allowed for the incremental cost of dissemination, and that is a much cheaper cost than the market rate that ASTM sets in this case.
Is something for Congress to consider?
Well, we think that Congress did consider it when it set this reasonable availability standard, and we think that under the plain
But you agree that, your point is reasonable availability means for free.
But we think that reasonable availability means that it must be published somewhere within the public domain, which by its nature is free.
And the public domain you define as what? I'm thinking of the history of this country.
Mm-hmm. Yeah,
and laws were not in the public domain. And I'm not saying that's good or bad, but I mean, I'm just trying to understand where you're coming from.
Well, I think, Your Honor, dating back to the founding laws were always within the public domain because
they weren't. They were in the house. Somebody who lived in Georgetown and you couldn't get them. I mean, there were terrible problems of access to public laws.
I was interpreting Your Honor's question to mean public domain in like the ephemeral sense of like.
I'm just trying to say it's not as clear cut historically.
Yeah, I appreciate that, Your Honor. And what we've argued in our brief is that the current standard of 2 physical copies available in Bethesda doesn't even meet the standard of 1795 when the government was distributing the law through the newspapers. And we've argued that what is reasonable evolves with time. And as the machinations improve to allow the government to make the law more accessible to the people, access to the law should improve as well.
Well, in this day and age, it's the year we've all been through. we know there are many ways to make things publicly accessible.
Right.
And the reading room in Bethesda may be fine if you can access it over Zoom.
And perhaps that would be that is, and that's why we think reasonable, to some extent, reasonable available is a squishy standard, because there are, like Your Honor just mentioned, there are things the agency could do to make the rule reasonably available. But what the agency can't do is relinquish control over that availability. And my colleague for ASTM said that they wouldn't interpret exploitation in their licensing agreement to mean fair use, but in that licensing agreement, you also have to give up any copyright claims. So how are you supposed to present a fair use defense if and when ASTM goes to enforce this licensing agreement against you? And
let me ask you, did you have any response to any of the jurisdictional arguments that were made?
Yes, I did, Your Honor. Thank you for asking. As a preliminary matter, we would just, if this court thinks that it needs to decide this case on jurisdictional grounds, we'd appreciate an opportunity for supplemental briefing that exceeds the 250 words that were allowed in the 28J response. But
well, we gave you public notice that we were going to no, I'm serious, counsel.
Yeah, no,
we didn't even have to do that because you know that as an attorney. First of all, does the court have jurisdiction?
Yeah, Your Honor, and I would say that the first place that I point you is to the Federal Register, where not only was the rule styled as a conditional rule that may or may not take effect pending some further inaction by the agency, the Federal Register also says this rule is approved by the Federal Register as of December 22nd.
Sorry, the Federal Register says the action, this is a direct final rule.
Your Honor,
Not styled as a proposed final rule or a conditional final rule.
And Your Honor, I think a response to that is that in last year's Little Sister of the Poor case in the Supreme Court said it's completely immaterial what the agency decides to call its rule. What matters is what the rule says and what the rule is actually doing. And in this case, even though they've called it a direct final rule, it is in fact a conditional rule. And by the terms that the agency set out, and I'd note, Your Honor, that we filed our petition in February within 60 days of the effective date, which in our view was when the rule was formally promulgated. The agency did not object to that. So I read that to think that the agency was under the same impression that Ms. Milice did. The agency looked at what it wrote in the Federal Register and said, you know what, this rule did not become final until December 22nd. And so everybody was proceeding under the same assumption that promulgation was the effective date in this case. And I recognize that that's not typically the case when the rule goes through the formal rulemaking process. But when the agency is going to propose a direct final rule, which is in effect a conditional rule, it does not become final agency action, and it does not consummate. It's not a consummated agency action through the rulemaking.
Hadn't filed if no letter had been filed, no comment had been filed at all.
Yeah. Oh,
it would have remained a direct final rule.
So I appreciate that question, Your Honor. So it brings me back to the point that you were asking of my co-counsel, and the comments that are filed are available on regulation.
No, I'm asking you a different question.
Right. And so
because time is very late here. We've given you way extra time here. So
yeah,
if no comment at all had been filed, none, not by you, not by any, it would remain a direct final rule.
If no comment had been filed, there would be no reason for the public to believe that the rule was
not. The condition wouldn't have been met, and it would remain a direct final rule.
Correct.
Right.
And we don't believe that the rule that you're only securing that right for the commenter. We think when a comment is filed that puts the public on notice on regulations.gov that this might be pulled pending further agency action. The agency has to review this to see whether or not that the agency deems it to be an adverse comment. The public is then on notice that we're in this tentative stage and we don't know whether the rule is going to become final until its effective date when the agency has failed to act.
I'm not sure I understand your response to Judge Millett's question.
I'm sorry, Your Honor.
If no one had filed any comment at all, what would have been the effective date? I'm sorry, what would have been the promulgation date of the rule under your theory?
Again, it's a different case, but I do think that there's a much stronger argument that could be made that had no comment been filed, that there was constructive notice to the public as of the end of the comment period, that there were no adverse comments and the rule would take effect. And then that constructive notice would place the public on notice, obviously, that there was going to be final agency action. And so it's a different situation.
Give me a date, please. If no comment had been filed, what would have been the promulgation date that would start the clock ticking for jurisdictional purposes under your construction of everything?
Under our construction of everything, I think that the December 22nd would remain the promulgation date because there is no way for the public to fully know, and that's why other agencies file a confirmatory notice in the Federal Register to alert the public that the rule will in fact become final as proposed. And that's not the path CPSC took. And I appreciate Your Honor's question, and there could be a stronger argument that if there were no adverse comments filed by anyone, there was no public notice that this might be pulled under that theory. But the way that the rule was published in the Federal Register, it says this will be deemed published in the Federal Register as of December 22nd, 2019. So that has to be the final agency action in this date because that's how CPSC structured its rule. And that rule shouldn't be now construed at this later date to impede the rights of the public to file a challenge to that agency action.
All right, I think we have your argument. We will
Thank you,
take
Your
the
Honor.
case under advisement.
This honorable court is now adjourned until Tuesday, May 11th at 9:30 a.m.